So I think we're ready to go. If anybody can hear me, Ambassador Cooper, Mr. Secretary General Miguel, excellent. Good afternoon, everybody, and good afternoon to our audience, and welcome to the panel on being a lawyer diplomat. My colleague, Professor Peggy McGinnis, is joining us. We're very glad that you have also joined us for what is certain to be a very interesting and informative conversation. We are honored and delighted to have three exceptionally highly qualified discussants this afternoon who've agreed to take time from their very busy schedules to share their insights with you. I'll introduce them very briefly in the order in which I've invited them to speak. And then we'll have questions following that. The Honorable Miguel de Serpa Suarez is Under Secretary General of the United Nations for Legal Affairs, in which capacity he also serves as the UN Legal Counsel. Before taking up these duties in 2013, he was the Director General for Legal Affairs of the Portuguese Foreign Ministry. Ambassador Katrina Cooper currently serves as Deputy Chief of Mission of the Australian Embassy here in Washington, a career Foreign Service officer in the Australian Department of Foreign Affairs and Trade. She was previously Ambassador to Mexico and Senior Legal Advisor to her ministry in Canberra. Mohammed Halal is an Associate Professor of Law at The Ohio State University and is currently serving as Legal Counsel to the Egyptian Minister of Foreign Affairs, in addition to teaching international law at Harvard Law School, where he's a visiting Associate Professor of International Law. He's also a member of the African Union Commission on International Law and was recently appointed to the Permanent Court of Arbitration in The Hague. So together, these participants have broad but very diverse experiences, and no doubt will bring some different perspectives and insights to the questions to which this panel is addressed. As indicated in your program, the questions are: what is or should be the role of lawyers who participate in the conduct of diplomatic relations? How do law and diplomacy interact, and what makes a good international lawyer? We have only 1 hour with a hard stop just before 3, so I've asked the panelists to speak to these questions for perhaps 8 or 10 minutes, after which we'll provide them a brief opportunity to comment and respond to each other, and then we will open the floor for questions from you, the audience. So please be thinking of your questions as we go. I invite also Professor McGinnis to intervene as she thinks is appropriate. You can use the chat function, I'm told, to pose your questions. Please direct them to me, the moderator, David Stewart, or if I disappear, to Professor McGinnis, so that we can keep the queue. I'm asked to remind you all that this panel has been approved for continuing legal education credit. And I'm trying to figure out how to share that screen. There it is. No, share screen. Yes, there we go. You should, in order to obtain credit, you should write down the code that is shown on the screen, enter it into the CLE affirmation form. That form, I'm told, is available on the conference landing site. You have to submit it no later than November 5th in order to get credit, and you submit that to the conference organizers. Please do write down the code. You cannot get credit without it, and it will not be shown again after this panel.
David, I'm not sure everyone can see the screen, the shared screen.
Okay, I'm sorry. Let's try it one more time.
Yeah.
How's that?
There it
so
is.
write down the code, and I am told I have to show that to you again before the end of the session. So without further introductions, let me turn it over to Miguel.
Thank you, David. Thank you, Peggy, and thank you for organizing this in this COVID-19 time. It's good to have some sort of events. We try to have a sense of normalcy. So I'm very pleased to be here. Listen, I think I would like to start by saying that international law as such is more and more a component of international relations. And ideally, international law should be the language that states speak between themselves. One of the interesting things that I have observed is that every state in every circumstance tried to articulate a legal position of some nature. Of course, we can discuss the merits of that legal position, but I've never seen a state saying, I don't believe in international law, I don't respect international law. Every state at each moment tries to articulate a legal position of some sort, being in Iraq, the invasion of Iraq, being Crimea lately. So you don't have any state rejecting international law as such. And on this question on the interconnection between law and diplomacy, I'm not talking about the most easy examples, which is diplomatic processes which have as exclusive aim the negotiation of a new treaty, for example, because there you have an entire diplomatic process which only aims at adopting a new text, and this is very much what we do in a multilateral environment and in the United Nations in particular at this stage. And after 75 years, the Secretary General is depositary of about 600 multilateral treaties. And there are a few new ones being negotiated right now. And I'm sorry to introduce again the biodiversity beyond areas of national jurisdiction, which is a topic I treasure very much, but it's an example of a diplomatic process which is taking place. It's a formidable negotiation machine with diplomats, lawyers, and other experts, because more and more, we can't work alone. I think more and more diplomacy as such is a specialized activity. More and more has to work with different types of experts. So I think people still, a lot of people still have this very glamorous image of diplomats meeting in receptions, and it's the day-to-day life is a little bit less glamorous and a little bit more technocratic. Let's see what Katrina Cooper thinks about it. But we all have to work together. And also, we also have other forms of legal diplomacy as such. International fora where we lawyers meet and discuss legal topics, at the 6th Committee of the General Assembly, which is actually meeting right now, but other regional forums like the Committee on Advisors of International Law from the Council of Europe, was not only members of the Council of Europe, but other observers like the US, Australia, for instance, Mexico, and they meet twice a year to discuss legal topics. Also in the European Union, you have this kind of groups. Now, the first thing I think that for diplomats, working without having a lawyer in the room is, first thing, a risk. And I'm going to give you an example without indicating the country, but I mean, 3 years ago, many of my colleagues were very excited here because they had achieved a ceasefire in a particularly complicated part of the world. And that was very good. But then when we tried to operationalize that ceasefire, there was no lawyer in the room, and we have just noticed that the ceasefire didn't have a day and the date in which it would start. So this is a very extreme example of, it's useful to have a lawyer in the room, at least to make sure that everybody is clear about their commitments. One of the areas that I find it very interesting, the intersection of law, diplomacy, or international politics, is whenever we have to analyze in, a very discrete manner, all situations related to use of force and invocation of self-defense under Article 51 in the Charter. Because for lawyers, we need to explain to our political masters what is the legal background and what is the legal framework of this discussion. But very often, we depend on a narrative, on facts that we don't have, and that we need to collect through different sources. For instance, in the last situations involving Syria, we have to sit here in the Office of Legal Affairs and trying to listen very carefully to the intervention of the British Prime Minister in the Parliament or the French President, and try to get as many factual indications as we can in order to make our own assessment. So after my years of experience, what I think is that we have to work together. I think diplomacy without some sort of legal input is weaker. I think our role is generally appreciated by the diplomats. By the end of the day also, it's important for us lawyers to keep in mind that a certain solution for a certain situation may go beyond what's legal or what is the legal analysis of that situation. This means that sometimes we can have a very clear analysis from an international law perspective of a given situation, but that legal certainty and clarity does not necessarily contribute to an equitable solution of the problem. I give you an example, what's going now on Nagorno-Karabakh. We are ready to make our legal analysis of the respective positions of the two countries involved in this process. But by the end of the day, the solution goes beyond that. And the solution, if it's a solution anchored in law, we can presume that it's sustainable, it's solid, but the work does not finish with us lawyers. So this relationship is constant. Let's say that our role of international lawyers is to make sure that more and more law, and in this case international law, is an essential component of the decision-making process. That's what I try to do on my everyday life, and if I achieve that, I'm happy, and I think I have fulfilled my duty. Over to you.
Thanks very much, Ambassador. You are still muted.
I'm now unmuted. Look, thank you very much, and thank you for those really interesting observations, Miguel. I'm very, very happy to be on this panel. So thank you so much to David and Peggy for initiating it. And that's because it fuses two of my great passions, and in fact is the story of my career. As you said, I've been in the diplomatic service for nearly 30 years. I'm a career diplomat, but I've spent almost all my time when back home in legal roles because international law was really my first love before I joined the service. So I see them very much as two distinct disciplines, but they exist in what I see as a very mutually beneficial symbiotic relationship. And I really love the fact that I've been able to do both in my career, because I feel I have a policy self that understands the policy imperatives, but then also a legal self that understands the legal parameters and constraints. And in fact, sometimes I find I'm arguing with myself at times on issues, trying to work out where the middle ground lies. But look, I think there are some overlapping skills, which I think is really important to understand. Obviously, as an international lawyer, you need to know the law. You don't need to know the law as a diplomat because you have lawyers on which you can rely. But to be a good practicing international lawyer, which of course is different from writing a book on international law, to be a good practicing international lawyer, you need strategic vision, because you are advising on issues that are going to have long-term effects and that feed into a policy process. You cannot do it in isolation or in a vacuum. So I think good strategic vision is really important. Secondly, you need to know how to build constructive relationships. And I'll get to that a little bit in a minute when I talk about what I think is really the holy grail of legal advising. The third thing is you need to be a problem solver. Oftentimes we hear lawyers being spoken about as many different words, some of which aren't suitable for this forum, but the essence of which is that lawyers act as a brake or a barrier, and usually it's accompanied with a sigh or an eye roll about the lawyers. So you need to be a good problem solver. That's the sort of mindset you need to bring to international legal advising. And of course, you need to be an advocate. You need to be an advocate whether you're a diplomat or whether you're a lawyer. In the case of being an international lawyer, you need to be an advocate for the rule of law. So you almost have the law is in a way your primary client. So I think you need those three skills as well as international legal expertise. And I think for me, the holy grail of international legal advising is where you're able to create a virtuous cycle between the legal advising and the policy process. So a situation where your legal advice informs the policy process, and the policy process in turn helps to strengthen and clarify, and in some cases make international law. Now, to achieve that, I think you need three things. And in a sense, they partly go back to the constructive relationship point. You need a very high degree of trust between the legal advisor and a client. For me, that's the overriding imperative. If trust breaks down, it becomes very difficult. And in fact, I would even venture to say that it's impossible to be able to provide legal advice if you don't have that relationship of trust. You need then to have that trust, almost like a subset of that. You do need a willingness on the client's part to accept international law advice. Now, from my experience, leaders don't often come fully formed with that mindset. So it is part of the legal advisor's job to persuade the decision maker that is an important input, if you like, into their policy making process. That international law is vitally important, and for a whole range of reasons, obviously. And I think the third thing you need, which goes back to the skill set that I was talking about, is a capacity on the lawyer's part to engage constructively with the policy objectives. So when I was the senior legal advisor, which I was for 5 years before taking up my current role, I would say to my team, when somebody comes to you and asks you for advice on how to do X, or if they come to you and they say, I want to do X, can you give me the legal advice? I used to say to them, before engaging or embarking on that process, first sit down and have a conversation with them and find out what their policy imperatives and objectives are. It might be they actually don't want to do X, but they want to get from A to B. And as they've thought about it, X is the only solution that they can come up with, or the only pathway that they can come up with. But if, as the international lawyer, you understand where they're trying to get to, because you bring that international legal expertise to the table, you may be able to find other better pathways. So I think that first conversation between the international legal advisor and the policy decision maker needs to be a conversation. And sometimes we see that a decision maker will say, I want advice on X, and the response will be, you can't do that. And that sort of ends the conversation. You really need a beginning that opens up the conversation. In terms of how the law, so that's sort of the broad, how does it all work in almost a theoretical construct. Some of the ways that lawyers engage, I think, very effectively in the policy process, one of the most common, and Miguel's mentioned this too, of course, is advising on negotiations. And I think every negotiating team should have their lawyers with them. The lawyers bring that expertise. They've got a nose and training for risk and for pitfalls, and they can help to guide the negotiator and the policy decision maker through that policy process. And in some instances, the international legal advisor is an excellent tool policymakers are not at all afraid to use. I've heard lead negotiators say many times, well, I'd love to do it, but I don't know, my lawyers, they just won't let me do it. So when a legal advisor is working very well within a negotiating team, it's a very close and constructive relationship. I think some of the more challenging areas on which we are asked to advise. And interestingly, Miguel singled out the one that I have personally found one of the most challenging as well, is Article 51 of the Charter around the use of force. That is an area of advising which requires a great degree of skill, deep understanding of the law, and as Miguel says, the facts are not always clear, and oftentimes actually the time frames are very, very short. But I think it's, you know, never do you see, to my mind, a more important moment for international law when advising on those sorts of very difficult and complex, and in some cases unsettled areas of the law. That's a second example. The third one, which I'll just mention briefly, because it's something that I spent a couple of years on before I came here, and that is there was an unusual process that I was engaged in, which was a compulsory conciliation, which was invoked by Timor-Leste against Australia under Article 298 of the UN Law of the Sea Convention. It's a very unusual process, a compulsory conciliation, and it was the first time it had ever been invoked. And it proved to be a very, very successful coming together of both law and policy. It was a sort of a hybrid arrangement. It wasn't actually a court or an arbitral tribunal, but it was a commission that was set up by both parties. And through that, we were able to navigate both using the law and using diplomacy with the help of the commission to come to a settlement on the maritime boundary between Australia and Timor-Leste, which we had failed to do for many years, using separately diplomatic means or indeed legal means. So I think that's just another terrific example of where international law and diplomacy can work together. And I'd just like to close by invoking a good friend of mine, former legal advisor of the State Department, Harold Coe, to put the question out there, because he asks the question about whether a legal advisor should be advising on not only what is unlawful, but what is awful. I think that's a really interesting question. You know, is the legal advisor the moral conscience of the government or of the decision maker? And that's something that others might want to explore. But I would say proceed with caution on that if you are an international legal advisor. If there are awful legal consequences, I think you can inject yourself quite readily into that space. If it is a purely awful policy outcome, then I think you do risk some stepping outside of your lane, which can undermine your credibility. But I would say that that's where the good relationships come back in, and you can have an informal side conversation with the person in charge of the policy to say, well, that's a pretty awful outcome, isn't it? And have you thought of X, Y, Z? But I raise that because it is an interesting, to me, ethical question. How far does the responsibility of the legal advisor extend? And I'll leave my remarks there. Thank you very much.
Thank you very much. Professor Halal.
Yeah, thank you, David. And thank you and Peggy for putting together this panel, and just for all the attendees here. You know, part of this panel is also preparing for a fabulous book that David and Peggy are editing on the practice of law and diplomacy. So look out for that. That's going to be really exciting. So I'd like to start off by engaging with David's first question about how do law and diplomacy interact. And my approach, or my views on that, are based pretty much, and I'm borrowing from Karl von Clausewitz, that in my view, the exercise of law is an exercise of politics by other means. As we all know, Clausewitz said that war is politics by other means. In my view, the exercise of law by a diplomatic officer is ultimately an exercise of politics and an exercise of the pursuit of the interest of the state through the instruments and institutions of the law. And in that sense, in my view, there's not much difference between the lawyer and the diplomat who is perhaps specialized in other areas of the practice of diplomacy. So if we look at the General Assembly, I don't think there's much of a difference in terms of the mandate and role of the lawyer when compared to her colleagues, say, in the first committee of the General Assembly, which deals with arms control and disarmament, or their colleagues in the third committee that deals with human rights, or in the fourth committee that deals with special political issues and decolonization. And so what this essentially means is that as a lawyer representing the state, the ultimate objective of that lawyer is to utilize the instruments of the law and to utilize the instruments of international institutions in which the law is often practiced to pursue the interest of the state. Now, I realize that for many international lawyers, including, I would guess, someone having read many of his writings, someone like Harold Coe and others, that it is perhaps almost blasphemous to describe the role of the international lawyer in these terms. In fact, it's very popular in the profession of international law, and particularly in academic writing on international law, to present law as the antithesis of power, and to present law as somehow the instrument through which we limit the impact and role of power in international relations. Now, while I see the virtue and logic of those arguments, I think that from my practical or professional experience, what I have found is that ultimately law is an institution of power. It is an expression of power, only it takes a different form. We usually think of power as being either hard power, such as the military, or economic and financial power. And recently, Joseph Nye introduced the concept of soft power. But I think it's plausible to argue that the law is also a form of power in the sense that power is ultimately a mechanism of control. It is a mechanism that governs the behavior of entities at the international level, primarily states and obviously many other actors. And if the objective of law is to regulate and govern and channel the behavior of entities engaged in international relations, then I think it's very plausible to argue that law is ultimately a form of power. And so, from my perspective, the role of the lawyer-diplomat is a diplomat before being a lawyer, in the sense that her or his objective is to pursue the interests of the state, to be able to speak the language of the law and to understand the intricacies of the institutional infrastructure of the international system, to be able to pursue and promote the interest of the state through the institutions and structures of the law. And so obviously, my perspective is very much based on the role of the diplomat acting as a representative of her state. Obviously, if I were thinking of the role of the diplomat as an international civil servant like Miguel, or a diplomat or an individual engaged in international diplomacy as a representative of civil society, or any other role, for example, in a judicial position, those individuals in those positions would approach the law and would approach the practice of diplomacy in many different ways. And so I think sort of the bottom line for me is there's no one single answer to how do law and diplomacy relate. And there's no one single answer to what is the role, what is the sort of ideal role of the lawyer-diplomat, primarily because it's incredibly situational. And depending on where an individual and what kind of diplomacy an individual is engaged in. But if you are the representative of the state, your primary role, the constituency that you are serving is your national, is your essentially your home government and the people, the people of your country, basically. That's the constituency you're serving. And it is your job to utilize the law to serve their interests. And so building on what Katrina was saying about the conversation with your policy colleagues, which I agree entirely. I agree entirely that it's absolutely essential to have a constructive conversation and a relationship with trust with your policy colleagues. I think sort of building on that, some of the advice I would give is that the entry point to establish your credibility as a lawyer is to have a clear understanding of the interests of the state. And the concept of interests of the state is, I think, one of the least well understood concepts in international relations literature. And I think that in the next few minutes, what I'd like to talk about is the idea of the multi-layered, multifaceted concept of state interests, which I think is essential for lawyers to be conversant in. So first and foremost, state interests are either short-term or long-term. And I think lawyers have an incredibly important role in being able to articulate the long-term interests of the state and to understand how international law and international institutions could be used to achieve long-term interests of the state. Moreover, I think lawyer diplomats have to be very cognizant that interests sort of exist at an international level and at a domestic level. Again, from my practical experience, I've found that maybe 70% of the time is involved in negotiations domestically. And so the process of articulating the national interest is a process that lawyer diplomats have to be deeply engaged in. They need to realize that you're often negotiating domestically with other agencies and with other constituencies and stakeholders, both within if you're in the foreign ministry, sort of within that department, but also in other government agencies. I think lawyers have to be very sensitive to the reputational interests and the reputational costs that are involved and that are generated by engaging in international legal diplomacy. There's also and I think, sometimes we don't like to talk about it, but there's also the institutional and bureaucratic interest. As lawyers and diplomats, we're bureaucrats. We are little cogs in a large bureaucratic machine, and often establishing trust and credibility and being taken seriously as part of the conversation involves watching out for the bureaucratic interest of the institution that you're part of. And then another role for the lawyer diplomat, or another sort of angle or another dimension of state interest, is that at times the international lawyer acts as an engineer, or what we call sort of a social engineer, in the sense that lawyers are sometimes called upon to engage in large exercises or sort of long-term exercises of establishing institutional and legal structures that govern relations on the long term. And I think in those instances, the lawyer becomes absolutely essential. But in addition to those sort of great moments of glory when you're sort of negotiating something as grand as the Vienna Convention on the Law of Treaties or the UN Convention on the Law of the Sea, there are also other smaller, I wouldn't say smaller, but no less important areas of diplomacy that lawyers are absolutely essential to. And in that vein, I'm thinking of consular relations and consular protections, sort of the daily routine work that lawyers are engaged in, which often sort of falls off the radar and doesn't attract as much interest and glamour as some of the larger issues like Article 51 or decisions relating to war and peace. But there are also sort of the day-to-day management of legal diplomacy that is absolutely essential. So I guess in conclusion, I appreciate that Katrina sort of presented the two professions as two distinct disciplines. I think in my mind, ultimately the lawyer diplomat is a diplomat that speaks a particular language, that has a particular expertise that is deployed to achieve the long-term and short-term interests of the state, much like any other diplomat. And I think my main takeaway would be I don't think that it is, I think experience and history have shown that ultimately law and diplomacy are different instruments in the pursuit of state interest and ultimately in the exercise of politics. Thank you, David.
Excellent. As promised, I think we'll give each of the speakers a minute or two to respond if they like, not necessary before we go to questions. So if you have any questions, and I see we have two already, please put them up on the chat so we do have the opportunity. So Miguel, would you like to respond or make comments on the prior presentations?
No, I just wanted to add one small comment on this policy legal separation. I mean, I never had that luxury in the sense that for the past 15 years, I was asked to do both. But I also have to tell that that's the main interesting aspect of my professional life, is the fact that I have to do both. And maybe some people find it confusing to separate in their heads what's policy, what's legal. And when I arrived in the Office of Legal Affairs of the United Nations, I was sometimes confronted by my own lawyers telling me, oh, that's policy. I said, well, wait a minute. Can I decide what's legal, what's policy? No. Some lawyers have some resistance of embracing a more policy role, which I think it's wrong for many reasons. Again, I don't have that luxury because I'm the legal counsel of the United Nations and the USG who sits in the board of the United Nations and so on. And it sometimes happens that I ask for the floor when we are discussing with colleagues and with the Secretary General of the United Nations, and I clarify I'm going to speak as legal counsel now, because I can in my head, you know, very clear have the intellectual separation in both roles, and I live very happily with both. That's what makes my life interesting. And also, Katrina, just to say that I was so happy because the ceremony with East Timor and Australia was one of the first public ceremonies that the Secretary General attended here in the UN. We have made a very nice ceremony. I was very, very happy because to pick on something that Mohammed was referring, this is also the, you know, the day-to-day life, the small victories that become particularly welcome and rewarding. So that was a good moment. Thank you.
Pastor Cooper?
Thank you. And thank you for that, Miguel. Yes, I was at that ceremony. It was really gratifying to be there. It is a really terrific and inspiring story, I think, about how treaties can be such useful instruments for dispute solving, even in the most difficult of circumstances. I just wanted to make one point before opening to questions about the issue that, you know, the thesis of Mohammed around, you know, the interests of the state and law as an instrument of power. And I think that is one way to see the law. I think where it becomes most interesting, which is certainly the case in my government, where the government is really committed to the rule of law as a fundamentally important tenet of identity, if you like, of international relations. And where the most interesting decisions and discussions come in is where there is a tension between that desire to uphold and strengthen the rule of law, the international rule of law, and there is a policy imperative that is pushing back against that. And it's particularly in those circumstances, I think, where there can be two competing interests, where the international legal advisor really needs to be an advocate for law and for the rule of law, and make clear to the decision maker why why the law should influence the decision of the policy and you are arguing for the interests of your state, but you're really arguing, you're trying to put two interests one alongside the other and argue for one over the other. And to me, that's where the policy and legal interface becomes just so interesting and challenging.
Thank you. Professor Halal, any comments?
Yeah, so I think Katrina is absolutely right. And there's a question there in the chat that I think I could sort of use to sort of engage with Katrina's comments. And so the question there is, what if advocating for the state's interests means helping a state to continue violating international commitments regarding human rights, for example, like in the case of Egypt? Is there a way to push states to fulfill international commitments through being the counsel of the state? And I think that question is sort of very similar to Katrina's comments, which I think is spot on. So the way I see it, sort of engaging with that question, is the job of the lawyer is to highlight to the policy or to the decision taker the costs of violating international law, right? Ultimately, the lawyer is not the individual who ultimately takes the decision and decides whether or not the state is going to violate international law. I mean, let's be clear and honest. Sort of on a twisting the sort of oft-cited sentence from Lou Henkin, I think many states violate international law almost all the time. It happens regularly, but that decision is often not taken by the lawyer. But the job of the lawyer is to highlight the policy costs to the state of engaging in that kind of behavior. And so the question from the audience is, well, what about human rights violations? I think the job of the lawyer is to lay out the following. First, this is a violation of domestic law and international law in the following ways. It violates the Constitution, it violates domestic legislation, and it violates international legal obligations in the following way. And second, the following are the reputational costs that you are going to incur due to this violation. And you're going to incur this cost in the Universal Periodic Review at the Human Rights Council. You're going to incur the costs, and the next time you come up for review, at the Committee on Torture or the Committee on the Elimination of All Forms of Discrimination Against Women or what have you. And then there's an additional layer of cost in your bilateral relationships with certain partners. You're going to say, you know what, the Dutch are going to bring it up. And the next time you go on a bilateral visit to the Netherlands, or the next time you have to come up for the peer review process in the African Union, this is going to come up. To me, that's the conversation that the lawyer is engaged in. And that's the way that the lawyer sort of encourages the state to fulfill its international legal obligations. Again, the lawyer has to be conversant with the language of economics by basically saying, listen, this is the cost in terms of foreign investment that we are going to incur for a policy that violates international law. And ultimately, and if we're going to be realistic about it, often the decision maker is going to include these factors in the decision-making process. They're not going to be determinative. There are no trump cards in the policy-making process. The cost of violating international law is going to be part of a cost-benefit analysis that the decision maker takes. And the role of the lawyer is to be engaged in this conversation, not so much as an advocate of the rule of law as a moral precept or sort of out of a moral commitment to the international rule of law, but rather by explaining to the decision maker that violating the law has costs, and this is how the costs play out. So that you're part of the cost benefit analysis and part of that conversation.
I'm reminded, I think, of a comment that Dean Coe once made, Master Cooper, beyond the awful but lawful or related comment, which was to the effect that the lawyer should never say yes when she should say no, but should never say no when she could find a way to accommodate the policy objectives of her client, at least to some degree. And I think that's not entirely different from a lawyer in private practice who has let's say, a corporate client. You explain the risks and you say, well, we can get you here. We can't get you all the way you want to go. And if you want to do that, here are the risks, the costs, what you want might entail. It might entail a prosecution. It might entail an investigation. Lots of other things. So I think, but that presents a kind of a circumscribed rule for the lawyer in the diplomatic context that says that you don't necessarily have a red flag. You can't stop everything. In my experience, there were one or two moments when I thought something would violate the Constitution, and I thought that was a pretty powerful argument to make. That's pretty much a showstopper. Others may have different views. Professor McGinnis, we give you the first comment. We take a few from the audience as we go.
I'm going to skip commenting because we do have quite a few audience questions, and I think it'd be nice to get them in before the anointed hour.
Would you like to pick
to say, Miguel? Your mic, you're on mute. Miguel, did you have something to say? Okay, got it. Okay, so I'm going to read. This is actually a question for Miguel from the chat box from John Kim. I don't know if you could read that. The question is, do you believe a UN legal advisor who worked previously in the Foreign Office of his or her country has a legal duty to refrain to deal with a legal question if the legal question is directly related to his or her own country's practice or policy? If so, is this the current policy for attorneys at the UN in your office? I might broaden that out for sort of a broader ethical question. It does circle back to a point Mohammed made about there's a different role when you are, at least Mohammed's positing that there's a different set of duties that exist for the traditional lawyer advisor to a state and the roles of lawyer advisors within international organizations, and then perhaps even lawyer advisors within courts or other adjudicatory bodies or even judges.
Thank you, Peggy. I had that in mind when I was listening to Mohammed talking about state interest, and I was like, where do I fit in there as a lawyer of the United Nations? So the reply to the question is no, in principle. There's absolutely no problem. When you become UN legal counsel, having been a national advisor, which is usually the typical CV of a UN legal advisor, and for a specific reason, you have an oath and you stick to that oath. You can evaluate, you can, in a particular situation, if you think that you are asked to opine on something you were particularly involved on your previous capacity, you may consider recusing yourself. To reassure everybody, in the last 7 years that I've been legal counsel, the only issue that crossed my office concerning Portugal was a very boring issue of taxation of pensions. So I was never confronted with that situation. There's also something I would like to add, is that on all the conversation we have been having before, the policy, the sensitivity to the policy, in the international organizations, you have different types of profiles in the legal departments. I have a particularly rich department in the sense that I have around 60 different nationalities. You have the typical international civil servant who joined the organization as a P2 or something and made his or her entire career in the organization and has absolutely no idea what is the diplomatic practice of member states. And some of them you even get, when you get into the United Nations, sometimes you even have the culture that member states are the enemies. And that the international civil servant, they know better. Member states, they don't know what they are. And to the most extreme cases, you even have some international civil servants in the UN who think they get a direct mandate from we the people, as in the preamble, forgetting they're not democratic elected, and then they get very much into the messianic approach to international civil service, speaking truth to power, and so on and so on. I have to say I have none of this culture. Member states are my constituents. I am very proud of my past diplomatic life. That helped me a lot when I arrived in New York, because coming from that world, I feel very comfortable, and I do that almost every day, to sit with ambassadors and discuss legal topics, sensitive ones. And I really appreciate the trust that some ambassadors have in me by accepting to discuss very sensitive issues. Of course, respecting confidentiality, which is fundamental for every diplomat. And once you have the culture, you respect it. Unfortunately, in the United Nations, confidentiality is not always respected. But, that helped me a lot. And it's very important that international civil service brings all these kind of experiences and this kind of people. That's what makes it rich, diverse, and effective. So in my case, I don't see a problem. It's a false question. In any case, just to be very clear, I never had an issue concerning Portugal other than taxation of pensions, which is a quite mundane, boring issue.
Thanks very much. Now I'm asked to show the slide again for the remainder of our time, but before I do that, let me ask, this will be the final, the jump ball, the collective question. If we can combine 3 questions from the audience. First, are the roles of lawyers and diplomats mutually exclusive or complementary and supplementary? A related question is, from a person who's not yet a lawyer thinking about the career, do you have any advice for me for starting my international law career? And a third, which is also related, how old were you when you were first aware that you wanted to be a diplomat? I'm 21 and still wondering, because it is a lifetime commitment. These all speak to, I think, the personal dimension of the careers you have all chosen and different paths you have followed. Very interesting. I'll just say that I'm one of those few people that I know who knew at a relatively young age that I wanted to be an international lawyer, long before I knew what that was, and I knew none of them in person. So I'm sympathetic to these questions. I think there are some people out there who are truly called to the kinds of careers that you variously have had. I wonder if you have advice to them. So in whichever order you like, maybe Mohammed, you go first, and then we circle back around with Ambassador Cooper and the Ambassador Suarez.
So answer to your first question, definitely supplementary / complementary. On the second sort of question regarding becoming a diplomat / lawyer, I knew very early on that I wanted to be a diplomat lawyer. But I think the way it started for me was that I realized that my passion was public international law. And what I did was that I sought to develop my understanding of public international law and my practice exposure to international law through being a diplomat, but also being an international civil servant and becoming an academic in the United States. And I think on that, I would say that your lifetime commitment, at least from my experience, is not necessarily to diplomacy, but rather to the law, in the sense that you're going to be a lawyer and an expert in the law, but you can end up practicing international law through many different avenues, not just diplomacy. So I would say that, you might end up, and I think David and Peggy are actually examples of this. They were in the US State Department Office of the Legal Advisor. They moved into academia. I served as a diplomat for my country for many years and as an international civil servant, but moved into academia and then back into diplomatic service. So it's not necessarily a one-off lifetime commitment, but you can go back and forth.
Thank you.
Can I jump in, David?
Yes.
I was going to jump in quickly, just as a minor correction to Professor Halal. I was actually a diplomat before I was a lawyer. So when I was a youngster, not quite 21, I took the Foreign Service exam and became a diplomat, and then chose to leave diplomatic service to get a law degree, became a private practitioner, and then joined the Legal Academy, joining my diplomatic practice with legal training. So
So you saw the light.
So, or I could say this book project we're working on is like Miguel and you and Katrina. I feel like it's a life's work. That's sort of the red thread, as we might say, through one's career. So.
Shall I jump in now, David?
Yes, please.
Yes. So I'm a little bit of a tragic, because I said these are my life's passions. So I was 14 when I realized I wanted to be a diplomat, 17 when I realized I wanted to be a lawyer, and in the early stages of my law degree, when I realized that international law and diplomacy would, as I think, two sides of the same coin. So early on, I knew, and I must say there hasn't been one day in my career when I haven't jumped out of bed enthusiastically for work. So I think if you can find a vocation that leads you to do that, then that's a very good thing. I didn't know if I was going to be doing this for this long, and here I am. That's because it's so endlessly interesting, and there are so many options in diplomacy, and I think you can also, as Professor Halal has said, take it in many other different directions. So I don't think this combination of study and skills is at all limiting. In fact, I think it's incredibly empowering and can be transitioned into many careers, even not non-legal careers or non-diplomatic careers, but careers that need the sort of skills that I spoke about at the beginning. And I think in terms of whether law and diplomacy are mutually exclusive or complementary, I think I probably answered that in my opening remarks. I think that together they're enormously powerful. It's a very symbiotic relationship. Yeah, I think it's a great combination.
Yes, please, Miguel.
Okay, so I have to confess, most of my youth, I wanted to be an archaeologist. So this is this is a bit different. Then my father was a lawyer, gave me the wise advice of going to law school. And then I was primarily interested in world affairs. So I wanted to go outside my community, my country, my continent. So that's what made me pursue a career in diplomacy and international law, although I've started by private practice, which I do not regret at all. I think that gave me a few good things for the future. As Katrina said, we are the result of all these experiences. So my advice for young professionals considering a career in diplomacy and international law is be curious, try to get as many diverse experiences as you can, because when I read CVs, and we're very lucky, whenever we have a position here, we get hundreds of CVs. When I read CVs, what I like to see is actually some diversity. People who show me they can operate in different scenarios and do different things, that already catches my interest. Learn a foreign language or two or three if you can. Get out of your linguistic comfort zone. I'm saying this as a non-English speaker. I think it's very important. It shows also to the world that you're curious about other cultures. Read the papers every day, please. I mean, it's important that you know where you are, what's going on. And one of the questions you didn't ask, but we referred to in last sessions is be creative, because this is something usually people do not associate with lawyers, but I need my lawyers to be creative. Every now and then I have to face totally new issues, totally. And we need to provide a background, a reply, and we need to construe something which is new. So be curious, be creative, read the papers, learn foreign languages, and do a lot of different things before you make up finally your mind on what you want to do for the rest of your life.
Excellent, excellent advice. And I think we're out of time. Professor McGinnis, do you have any short comments before we thank our panelists with a round of virtual applause?
Just a thank you to everyone. Thank you to all the participants and to our fantastic panelists.
Wonderful opportunity. Thank you so much for joining us. Thanks, everybody. We're going to close the session now.
Thank you, David. Thank you, Katrina. Thank you, Miguel. Obrigado.
Excellent.
Done.
Thank you.